All right, call the next case, please.
Mark Clayton versus Joseph Dixon et al.
All right, good morning and welcome. You're Mr. I'm sorry?
I'm sorry, Your Honor, and perhaps we should take this up before take up that motion before we start the argument.
We'll allow you to discuss that during your argument, and I doubt that we will make a decision today, but we'll take it under advisement. But you can do that during your 15 minutes. All right, and you are Mr. Mark Clayton?
Yes, I can.
Wonderful, and we're glad to have you here, and you're representing yourself, and you certainly have the right to do so, and I'm pleased that you had the opportunity to observe the prior case, because that gives you an idea of how we interact. We welcome anything that you want to say within your 15 minutes, and the court may or may not have questions, but
Welcome questions, Your Honor.
Thank you. And you may reserve up to 5 of your 15 minutes to respond to what Mr. Ellis says.
I'll reserve, Your Honor.
How much would you like to reserve?
5, just out of caution.
Very good. All right. We'll save 5 minutes for rebuttal, and therefore we'll set the timer at 10 minutes. And so the floor is yours, Mr. Clayton.
Yes, and I am pro se technically. I do want to address that. Any of the written pleadings were not to rattle sabers at the court. It was in a related criminal case and was just seeking to preserve Fifth Amendment rights on directly related litigation. So that was a foremost concern, and instead of allowing the crisis to create additional issues, I just attempted to mitigate the best I could by taking on the briefings myself. It's just a little bit of a learning curve to
It's a challenge even for lawyers.
To shop for an attorney for this type of law. So that's the spirit in which any written pleadings were made. Diligent pursuit of the rights. The issue here is that we have a riparian ownership case. You have a past condition and a present condition. The past condition is what the complaint is based on. It's a 42-inch pipe, which both sides agreed was insufficient, and in a settlement agreement, both parties agreed that the Dixons would put in a larger pipe. However, it has always been the position of the plaintiff myself that these things have to be done in accordance with public policy and the law, and a written agreement cannot be construed to be an endorsement. A mutual agreement of both parties cannot violate public policy. So the agreement has to be construed to be in compliance with the law. And throughout the entire process, the plaintiff attempted to follow the law, but not being the owner of the offending property, when it was unable to physically force outside of and take the law into his own hands and physically force the defendant to go through the proper procedures. They're actually quite complex, and what we have here is an attempt at an estoppel to say, well, there is a settlement agreement, therefore the court cannot get back to the original complaint and the damages. And what we're saying is that no, the plaintiff is not stopped from pursuing his claims and can't just anybody could dismiss their case for any reason, but can't dismiss the case based on the idea that the plaintiff has some sort of superpowers to waive federal, state, and local regulations to install the 72-inch pipe. So we go backwards and we start with the present condition, which is a 72-inch pipe, which does not meet the federal, state, and local guidelines. The federal guidelines are discretionary as to whether authorities will enforce them. This is not an attempt to. This is a 118B, 69-3-118B action. The plaintiff is not attempting to force the commissioner to take action. That's a 118A complaint. Or if someone wanted to file, the new jurisdiction venue rule is Title 20, Chapter 18 with the 3-judge panel. You can take those tacks. This is a 69-3-118B claim, and there's very clearly a private right of action. And the commissioner, the water department officials are, by the black letter law, excluded from being the person who is being discussed there. So the only possible interpretation of 69.3.118B is that there is a private right of action for private individuals who are riparian owners. It's possible that non-riparian owners could make claims as well. We're not asking the court to take that up today. What we're saying is that if we are a riparian owner and the case Ray versus Neff, we're using that as unreported, we're not saying that that's the precedent. We are using the standard of review in Ray versus Neff because it's a recent case from this court. And we're saying that the plaintiff has gone and followed all of the instructions and gone all the way down the list and done what the court has said and not taken the law into his own hands and said, these are the standard of review. You need an expert testimony. You need to prove causation. It's heavily burdensome, but it's not overburdensome. It's expensive, but it's not overburdensome. The burden can be met and has been met. And it's not a trick to imprison or tie somebody else up. It's a way of saying, the law is not in my own hands. This is what the courts have said. This is what the laws have said. These are the remedies that we have to pursue. And we can't just throw these out just for the convenience of the situation.
Mr. Clayton, let me ask you a question about the settlement agreement. Settlement agreement called for the satisfactory construction of an additional culvert, correct?
Yes.
72 inch.
Yes.
So how was it set upon that it would be a 72 inch culvert?
John Dewall, civil engineer, made calculations for that.
And so the 72 inch would be in addition to the 42 inch culvert?
No, that's just what the Dixons did. None of this precluded going through the normal processes. There's supposed to be design plans, even in the general ARAP permit where the state doesn't require you to go actually physically sign a permit. You have to have plans, specifications, you have to have design, you still have to meet all those elements.
I understand that, but I want to make sure I understand what the settlement agreement was designed to do here. So were there going to be two culverts then under this
Never
drive?
agreed to put two, that Dixon just decided to leave one.
Oh, I see. Okay. Thank
They
you.
just put it. But since I only have 4 minutes, I'd like to get off of that and say, the court's fully briefed on the summary judgment, the memorandum for summary judgment, and the supplemental memorandum. I feel it speaks for itself. I'd like not to take the oral time for that. And I feel like the relief requested is very self-explanatory. We went through and made sure we had exhibits of the forms that you're supposed to fill out with Metro and do these things. And I'd like to address a couple of things that are in the response with my remaining 3.5 minutes. The substantial completion was not made with the 72-inch pipe. It requires a contract with a contractor. Also, one of the things that the defendants are arguing is that there is an owner-possessor exception in repose, which is what the trial court erroneously granted on, was the repose issue. The repose statute only applies to contractors, and it does require to exclude an owner-possessor, it does require proximate cause, but proximate cause, according to the defendant's own briefs, is in dispute, and you cannot have a summary judgment based on a dispute on material fact, which is what they're saying about proximate cause. The chancellor's own order says that there's a dispute, possible dispute of proximate cause, so you can't grant summary judgment based on that. Also, we object to the idea that you can have these competing summary judgments and hear one and muddy the waters and not hear the other. I think if you take away all that noise and we go look at the plaintiff's summary judgment, it's very clear. It doesn't have to go into all of the weeds, and it supports only one conclusion, that if we're going to take these actions, we have to go through the process. Now, back to the summary judgment, that does deal more with the past condition, but what we're saying is we get to the past condition because the present condition under the terms of the settlement agreement did not meet the standard of review for a proper installation. And that's why we were talking about, that's why we're talking about the owner-possessor exception. The repose simply just does not apply to the Dixons. It's a temporary nuisance. The standards of review in Ray versus Neff are the proper standards of review. And we've even cited to the record where the defendants were on notice and stated that they knew that we were making that differentiation early on. One other thing is that damages needed to prove trespass can be nominal. They don't, you just be treading of grass. We're not wanting, the defense is trying to ask the court to conflate trespass and nuisance with damages. We're not in the damages phase yet. We're just trying to show nominal causation, which is required to survive a 118B complaint. And lastly, with my last 38 seconds, Hurricane Harvey cannot be an intervening cause. Even without the video evidence, the expert testimony and the calculations are enough to show that there's trespass and nuisance. We just happen to be able to get that one video. There were other rainstorms. And there are no speculative damages in this case. Speculative damages are damages which haven't been had yet. We're arguing about damages which have already happened. So I tried to put all that in there.
Well, thank you, Mr. Harvey. Excuse me, Mr. Clayton, and you'll have additional 5 minutes for rebuttal. Now we'll hear from Mr. Ellis, and Mr. Ellis, we look forward to your argument as well as your comments on the motion to consider post-judgment.
Yes, good morning, Your Honor. I appreciate the time to be here and be heard on this. Where I thought we would start is with the settlement agreement, because the settlement agreement was prepared by Mr. Clayton and his attorney, and the proof of that is, let's see, Technical Record, Volume 5, page 603, paragraph 19. Rules of interpretation in language of a contract where they're ambiguous should be construed most strongly against the party who drew it. That's Hanover Insurance versus Haney, 425 Southwest 2nd, 590, page 592. It's a 1968 case. And it's a basic rule of contract law that the party that puts any ambiguity into a contract, if they drafted it, then the language should be construed most strongly against them. In this case, it just said it shall be satisfactorily installed. And one of the reasons that we were interested in trying to get the commissioner's determination into evidence was because the commissioner's determination, which is after acquired, this was a determination under 69-3-118A that Mr. Clayton had referred to in his reply brief. It's a fact not in the record, but he had addressed it, and so once the report was complete, we thought it would be appropriate to bring it to the court's attention. And
so you asserted how did that work in the summary judgment stage here? Did you say in summary judgment, look, Judge, enforce the settlement agreement here? Was that one of the aspects of the motion for summary judgment?
No, Your Honor.
Yeah, so, why are we even talking then about whether or not the 72-inch culvert is satisfactory or not, when it sounds like to me you were attacking, look, even if you didn't have 72-inch culvert in there, the fact is the complaint still fails.
Right. Well, and the reason that we had brought that up is it had been discussed ad nauseum in some of the other pleadings, and I was just addressing it here if the court wanted to look at that.
Yeah, it seems like to me, I appreciate the motion's file, but it seems like the response here is well taken in the sense that the trial court really hasn't had a chance to visit this issue. The trial court may say, oh, well, there you have it, settlement agreement performed, this case should be dismissed on that basis, but the trial judge hasn't had a chance to speak on that point yet, so. Because
at the time, there was an issue as to, as a fact, it was a, material fact.
You didn't have the state sign off on it.
I didn't have the state sign at that time.
Let's focus on the statute of repose here.
Okay.
In the 42-inch culvert, which the trial judge here found was constructed in 2011. So your clients owned the property then?
Yes.
And they installed that culvert?
Yes.
Okay.
Yes, and and there was no permit pulled, but apparently there's no requirement for a permit to be pulled because the pipe is less than 25 feet in length. Now, what we have said and what we argued was that the plaintiff simply failed to meet his burden of proof in terms of showing injury. You got to have an injury before you can worry about whether there's a duty owed or breached or cause or proximate cause. Now, this is not a ambush. Beginning in March of 2020, in my motion to dismiss, we argued that there was a lack of actual damages. Nothing was shown as actual damages. There's a 20-foot easement that goes across the property. Now, that's not a trespass. That's a license. So the drainage easement allows for at least 20 feet width of water to be in the drainage.
Your position is, even if we disagree with the trial judge's analysis on the statute of repose, there's still an independent basis to affirm the grant of summary judgment?
Yes, Your Honor, because there can't be proximate cause if there's no proof of injury. And in the record, there is no proof of injury. There's proof of a 50-foot tree that blew over in a storm, but that's not a cause of my client's driveway. That's a storm that Mr. Clayton let grow up beside his driveway, and when the storm blew the tree over, it pulled the driveway up with it. That's not because of my client's driveway. We asked for lack of actual damages. In the interrogatories, I asked for photographs. I said videotapes. The only thing that was ever produced in terms of proof of damages, which is in the record, was the Hurricane Harvey event, which shows a torrential flood coming through both properties, and neither of these, I mean, I don't think it would matter what size pipe was down there. That was a huge torrential downpour, and the video shows that. I mean, I don't think anything at all would have affected that. So that's the only proof in the record of any flooding or trespass. So we've argued one instance in the record of flooding is not enough to show that there's an injury, and this was a monumental flood. Other than that, there's been no showing of damages, showing of injury. If you want to get to the damages phase and what the pecuniary cost of or problems that created, that's another issue. But there has to be proof of an injury before there can be causation or proximate cause. Now, because we argued proximate cause at length in our summary judgment hearing, I argued that they did not prove summary judgment. I cited the statute of repose exclusion in my brief and said that because they can't prove proximate cause, that the 28.3205 limitation is not a defense because they haven't shown any injury. We asked for injury. I asked for injury. All we got was that there were previous problems from 2004 to 2019. Every time it rained, his property flooded. I asked for dates. I asked his attorney for proof. We filed a motion to compel, and I got one date. Well, and actually, that wasn't even a date. There's not a date on that video. So we had nothing to compare the dates of the alleged trespass with weather records or anything else like that might have helped us evaluate what the significance of the problem was. So to that extent, yes, 28.3.205, yes, 28.3.205, it prevents a owner from using the statute of repose as a defense if the improvements are the proximate cause of the injury complained of. And because there's been no proof of injury, we argued that the statute of repose did apply, and the 4-year statute of repose eliminated his right to bring a cause of action in this situation because they had just failed to meet their burden of proof.
Mr. Clayton contends that the statute of repose only applies to contractors. What do you say to that?
Well, the statute of repose, it doesn't say that. Let me see. Water Quality Control Act. Substantial completion is defined by 28.3.201. It says substantial completion means that degree of completion of a project, improvement, or specified area or portion of the project, a as modified by change orders, upon attainment of which the owner can use the same for the purpose which it was intended. So substantial completion of the project means when the owner can use it for the purpose intended, it has been substantially completed, and therefore the measuring date for the statute of repose then begins to run.
Isn't there a contractor involved in that situation because it says change orders?
It says change orders, but let's say I build my garage, and I pull my own permits, or even if I don't pull my own permits, I hammer all the nails, I put up the walls, I put up the roof, I start using it as a garage, I park my car under there. Is it not substantially complete? Have I not completed the garage for its intended purpose? Does that mean because I didn't have a contractor, am I required to have a contractor to determine when a project is substantially complete? Or can I, as a homeowner, go ahead and put up my own structure on the property and have it be substantially complete because I'm using it for the purpose intended? So I would argue that requiring a contractor to be involved for this to apply is a stretch. I think substantial completion can be achieved by any person once the project has reached a stage where you can use it for its intended purpose. And that's something else that we argued, that it's substantially completed. It was intended to be used as a driveway. It's been used as a driveway. It was used as a driveway for 8 years before the complaint was filed. And so, Codes has been out there and had no complaint with it. The state of Tennessee has been out there and evaluated it, no complaint with it. So we submit that it is substantially completed. And since it was substantially completed and it's been used since 2011, that the statute of repose 283202 does apply, because it wasn't brought within 4 years of substantial completion of the project. And so therefore the statute of repose applies. The exclusion to the statute of repose does not apply because we haven't been shown proof of damages based on my client's driveway installation. That's not in the record. It's just not in the record. If there had been, Mr. Clayton cites Ray v. Neff as a case that he wants to go forward with. On page 9 of Ray v. Neff, the court says there were multiple pictures addressing this problem. And so I think it's distinguishable because in Ray v. Neff, there was proof of damages. There was proof of erosion. There was proof of other things. Mr. Clayton has submitted proof of some erosion around Mr. Dixon's driveway, but that's on Mr. Dixon's property. That's not a trespass to Mr. Clayton's property. It's part of his dissatisfaction with the completion of the project, which he's complained about, and we respect his right to do that. But as far as the dismissal of the case, we believe that the court properly dismissed it. But alternatively, if the court decides that we need to go back and discuss issues of proximate cause, then we also ask that we be allowed to revive our settlement agreement and other defenses that we raised in our answer and our countercomplaint, because those are material. We did ask for specific enforcement of the settlement agreement, and that was dismissed, and that's part of our appeal here, that if the court does remand it, we ask for permission to revive all of our affirmative defenses, including the enforcement of the settlement agreement. But
anything further, Mr. Ellis?
I've got 2 minutes.
Well, you're welcome to take it with you. Any questions from the panel? Hearing none, thank you, Mr. Ellis.
Okay, let me, thank you.
All right, thank you. Mr. Clayton, you have 5 minutes to respond to Mr. Ellis' argument.
I'm glad I reserved it. It's very clear that there are damages shown. The only, again, Ray v. Neff is unreported, but it is a fairly recent case that a lot of attorneys are looking at to see the preeminent standards of review from this court. And clearly says that expert testimony is required when ordinary knowledge is not enough. And the plaintiff went way out of his way without complaining about things being overburdensome to provide expert testimony. Not only an expert that would just say anything, we have the Delhi expert report is the fundamental. That's an exacting survey of the past condition and the present condition. It's not just a drawing. There are DRW files and exact measurements that any expert, which the defendants had, could have also availed themselves of and made their own measurements. They found nobody to do that with an extended COVID time to do it. And nobody else yet besides Mr. DeWall has made expert mathematical scientific calculations. And trespass and nuisance is proven because Mr. DeWall in his calculations, and just for the court to know, it's not a yes man thing. These people do not even need this kind of work. It puts them out to do this kind of work. He concluded that the 42-inch pipe did raise once it went and created a weir, which is the amount of water that goes over the top. And the calculation showed that you had a 0.9 foot raise in the water, which caused that, what you see in the video, which never would have happened had that 42-inch pipe not been put in. Then when the 72-inch pipe when that was put in, it wasn't put down properly to allow the water to flow, and it was raised up a foot even higher, creating another hydrological potential for difficulty, which automatically precludes it from being falling under the General Air Act permit because it may cause a hydrological issue. That's up to the Dixons to have to determine that. To go ahead and include this late state, first of all, the defendant should have been talking to TDEC before, not finding out 2 weeks before oral argument on something taken on my own initiative. That came out of a 118A complaint, and the commissioner refused to rule. So I exercised a 30-day window of appeal. This would be like going to a trial court and the trial court refusing to do anything and telling you just don't come back. So you put in an appeal, and then once it's in an appeal, the trial judge comes in as a party and says, hey, I want to show something to the appeal court. That's what the state's doing here with the 118A administrative court. That matter is properly under the administrative judge. This is not a game that I'm trying to play with this court to exclude this. It would be an appealable decision, but it wasn't even rendered until 2 months after the appeal got started and after a trial was set on an administrative level. The 118A issue is just to bring the commissioner to his duty. That's all it is. It's not so much about rights. I did mistakenly put something about Bill of Rights. It could touch on that, but a 118A is just to bring the commissioner and the state to its duty. That's just working through its process. Anything in that which conflates with this case is an ex parte violation of the Administrative Procedures Act between the defendants who are a party, and it's just a jurisdictional and procedural nightmare to try to even figure out what they're trying to say on that. But the other thing is on the Harvey issue, it's cited to the record. The appellees have admitted that there's a 25-year flooding that goes on with this. They say it's only 25 years. That's not an act of God. And they're agreeing with Mr. DeWall that what they had in there with their 42-inch pipe does cause a flood every 25 years. That's cited to the record. It's their own words. It's in the brief. So I have a hard time with them saying that there's no damages when in their own brief they're saying, well, it only backs up every 25 years. Well, if you lived in your house every 25 years, 3 or 4 times in a lifetime, you're going to have significant flooding hitting your property. And they're saying that that's an act of God, and I don't see how that can fly. And I don't see how they can dismiss the DeWall report as not being evidence of damages when it's the only evidence.
All right. Thank you, Mr. Clayton and Mr. Ellis, for your arguments. We will take them under advisement. And Mr. Clayton, what we do is the 3 judges will confer, and then one of us will be assigned the responsibility to write our opinion that renders our decision, and then that will be delivered to you by the clerk of the court. Thank you. There being no further cases on the morning docket, we'll be back this afternoon. If you'll recess court, please.
All rise.